All right, we're continuing here in the chapter on equal rights. We're going to be looking at slides number 29 through 32. And this is the continuing struggle for equality with the gay and lesbian community, okay? And this is kind of an interesting quest for equality, okay? Because a lot of what they've done in the last 10 to 20, 30 years has been nothing short of remarkable. And they've had to overcome a lot of, again, moral rejection of their lifestyle and behavior. And I'm going to draw a little bit from my background on psychology because, again, my undergrad was in psychology. But traditionally, homosexual behavior was considered deviant and abnormal. In the American Psychological Association, they've got something called the Diagnostic Statistical Manual of behavior, and where they classify normal behavior and abnormal behavior. And homosexual behavior had been considered abnormal. What they did in the early 70s in DSM-2, the Diagnostic Statistical Manual of Behavior, the second one, is instead of doing a lot of research, a lot of scientific research that determined that homosexuality was normal, they basically just took a voice vote of all the people in a particular membership meeting and said, hey, how many of you guys think you want to declassify homosexuality as abnormal? And in a majority vote, based on no research, they just kind of voted on it, okay, which is kind of interesting. So they declassified homosexuality as a deviant, abnormal behavior in the early 70s. And yet the typical pushback was, their behavior contributed to AIDS, which it did, along with intravenous drug use. Okay, this was a big deal in the 80s when I was, in high school. So the general consensus nationally against homosexuality was, it was a deviant behavior. A book came out in 1990 called After the Ball, written by Marshall Kirk and Hunter Madsen. Two individuals connected to Harvard University. One was, I believe, had a master's degree in marketing. The other had a PhD in political science, I believe. And basically, they were pro-gay in their agenda. And what they sought to do was to change the national opinion of homosexuals and homosexual behavior. So they came up with like a 5-pronged strategy that they tried to change how Americans think, and by and large, they were successful. First of all, they challenged those of the homosexual community to act normal, speak normal, look normal. In other words, try to normalize what you're doing. Don't look unusual, okay? Try to desensitize how Americans look at you so they can accept you. Second of all, they attempted to get as many homosexual characters in movies and TV shows, okay? Again, trying with something called desensitization. They tried to normalize the behavior. The thinking was, hey, if we can get a bunch of them in movies and TV shows, people think, hey, it must be normal. Third of all, and this is really important, they hitched their movement to the civil rights movement of the 1960s that sought to give equal rights to African Americans, okay? So homosexuals took on that same logic and said, listen, we are being denied civil rights just as African Americans were, so we need our rights too, okay? Which is, again, interesting because the rights that were denied African Americans, in the 50s and 60s and before then, was what they call, these rights were not fungible. In other words, they could not easily go from one diner or hotel to the other to get service. They were prevented throughout the country. The rights that homosexuals enjoyed was largely fungible. In other words, they could go wherever and still enjoy those kind of rights. But nevertheless, they hitched their wagon to the civil rights movement and said that basically we're victims. And because we're victims, we're deserving of equal protection. Fourth of all, they sought to promote their cause through a lot of Supreme Court and federal court decisions. And we've talked about a lot of these, and in fact, you can see these on this particular slide. The Romer versus Evans case, the Lawrence versus Texas case, U.S. v. Windsor, Obergefell v. Hodges, okay? These were cases that were decided in favor of homosexuals. Their thinking was, listen, we cannot get legislation through that will champion our cause. So one way we can kind of go around it is to try to get Supreme Court decisions to rule in our favor, and that thereby basically sidestepping, if you will, democracy or the democratic process of legislation, and they largely did it. And then the fifth strategy, I think it's five, the fifth strategy that they embraced was they sought to challenge anyone that disagreed with them and their lifestyle as a bigot or being phobic. Okay, in other words, they tried to push back against those that were again, those that had legitimate disagreements with their lifestyle and said, no, you're a bigot, you're some form of a phobic. And if you look at what has happened from 1990 to the present, they have in other words, they've actually done everything. And the book is, I read the book several years ago just to check this out, and it is pretty interesting that by and large, they accomplished their objectives. Now that, if you're thinking, well, Professor Gustafson, what are you saying? All I'm saying is you had a real savvy marketer and you had a real savvy political scientist that basically developed a strategy, okay, that in many respects, you could say sidestepped a lot of the democratic process to get a view across. And they used media, they used the courts, they used public opinion, but they used it in such a way that changed the narrative. Okay, so they attempted and have been successful in getting a lot of rights through, in particular, the courts. Okay, there's some challenges though that have emerged because of homosexual rights. Okay, and if you go to slide number 30, I just want to talk about three of them that have been mentioned by Supreme Court justices as they have dissented in cases that have granted new rights to homosexuals. In other words, one of the issues before the Supreme Court, it's always in constitutional law, is there a fundamental right deeply rooted in America's history and traditions that homosexuals, or pick your group, they've enjoyed? Okay, if the answer was no, they didn't have it at the founding, then the argument is always in constitutional law, or at least has been, that, okay, this right is not going to be granted to them through the courts. You're going to have to get it the old-fashioned way. Well, what's the old-fashioned way? Through legislation. You're going to have to persuade legislatures at the state and national level to enact legislation favoring your cause, or get an amendment. Okay, that's if I say the old-fashioned way, that's the constitutional way. That's how the founders set it up. Okay, they never saw these groups getting new rights through the court. They always thought the court was going to decide purely constitutional issues. If that right that this particular group wants is not in the Constitution, then by default, you get that right through legislation. It's not like you can't get your right. It's not that you can't get your equality, but the issue is get your equality through the constitutionally prescribed way, which is through legislation or amendments, okay? But since homosexuals have gotten a number of rights through the court system, there's three problems that Supreme Court justices have mentioned. I just want to talk about them briefly, okay? First of all, there's some religious liberty implications. Second of all, there's moral implications with regard to morality and rational basis review. Remember, we talked about rational basis a little bit earlier. And then there's implications with regard to democracy, okay? So if you go to slide number 31, these are challenges to religious liberty in the wake of Obergefell versus Hodges, okay? This is the Supreme Court case in 2015 that basically struck down state laws preventing homosexuals to get, in other words, to get married, okay? So this is one of the religious liberty implications. This is Justice Clarence Thomas's dissent in the Obergefell case. He said, aside from undermining the political processes that protect our liberty, the majority's decision threatens the religious liberty our nation has so long sought to protect. Numerous amici, these are basically lobbying that the court receives, all these lobbying briefs. Numerous amici, even some not supporting the states, have cautioned the court that its decision here will have unavoidable and wide-ranging implications for religious liberty. In our society, marriage is not simply a governmental institution, it is a religious institution as well. Today's decision might change the former, but it cannot change the latter. It appears all but inevitable that the two will come into conflict, particularly as individuals and churches are confronted with demands to participate in and endorse civil marriages between same-sex couples. Okay, these are some of the religious liberty implications. Okay, and if you look at slide number 32, you can see probably the most famous religious liberty implication, and that's the Masterpiece Cake Shop case. Okay, and this was a case in which a baker who was an avowed Christian, who made cakes and designed cakes as an art form for various and sundry groups of people, was approached by a homosexual couple that wanted to get married. And Jack Phillips said, listen, because of my Christian convictions, because of what I understand in the Bible, homosexuality is wrong, and I cannot in good conscience make this cake for you and celebrate your wedding. However, there's a number of bakers throughout this. I believe it was in near Denver. There was a number of other bakeries that can do it, and so let me recommend them to you. Okay, and so Philip's thinking was, listen, I preserve my conscientious objection, but I also serve this customer because I provided alternatives. Again, remember fungible goods and services. These goods and services are fungible. You can get them other places. In other words, Jack Phillips' shop was not the be-all, end-all, the only place that provided them. So basically, the couple got offended. Basically, took Jack Phillips to court. And said that their civil rights were violated because they were prevented from getting a cake from Jack Phillips. It went to the Supreme Court. The Supreme Court sided with Jack Phillips, okay? But again, what Clarence Thomas voiced in his Obergefell decision, okay, in 2015, Jack Phillips, I believe it was 2018, is a legitimate concern, okay? When homosexual rights and religious rights, in other words, individuals that have a legitimately held moral and religious opposition to a lifestyle that, according to their convictions, deepest convictions, is wrong, who gets the right of way? Okay, and Clarence Thomas was, I think, very prescient and said, listen, this is going to be an issue. Okay, second issue, okay, is if you go to slide number 33, challenges to morality posed by the expanded definition of liberty. Okay, in Lawrence versus Texas, this was a case where two individuals were basically caught in the act of homosexual relations by a police officer and in violation of a Texas law. Went before the Supreme Court. The Supreme Court sided with the homosexual couple. But the concern before the court, at least those that were dissenters, in this case, Antonin Scalia, was, okay, the people of Texas created a law that said the homosexual conduct is immoral, and they have a rational basis for doing so. In other words, there's all kinds of rational basis for moral laws against prostitution, maybe nudity in a public place. In other words, there's some moral convictions against that, and that's what they used to create the law in Texas. And so what Antonin Scalia was very concerned about is, listen, if you strike this law down and say, listen, morality doesn't matter in this, well, then morality doesn't matter in that. And then morality doesn't matter in something else, okay? And he was concerned about it. And so he said this, okay? This is on slide 33. The Texas statute undoubtedly imposes constraints on liberty. So do laws prohibiting prostitution, recreational use of heroin, and for that matter, working more than 60 hours a week in a bakery. He's actually referencing an older decision called Lochner. But there is no right to liberty under the Due Process Clause, though today's opinion repeatedly makes that claim. Okay, if you go on to slide 34. The Texas statute undeniably seeks to further the belief of its citizens that certain forms of sexual behavior are immoral and unacceptable. The same interest, again, he's talking about the rational basis for a law. The same interest furthered by criminal laws against fornication, bigamy, adultery, adult incest, bestiality, and obscenity. This effectively decrees the end of all morals legislation. If, as the court asserts, the promotion of a majoritarian sexual majority is not even a legitimate state interest, none of the above mentioned laws can survive a rational basis review. So at issue for Scalia was this idea that, there's going to be some implications with regards to, the rationality of laws that, prohibit, again, other areas that probably deserve prohibition, like the recreational use of heroin or things like that, okay? So So let's move on to the last one here, and that would be slide number 35, okay? So this is, again, granting new rights to individuals, okay, like homosexuals, where it's not written in the Constitution, and you sidestep democracy to get there, and you just go through the courts. It presents a challenge to democracy, and so let's look at Antonin Scalia's dissent in Obergefell. Okay, this is what he says: "It's not of special importance to me what the law says about marriage. It is of overwhelming importance, however, who it is that rules me. Today's decree says that my ruler, and the ruler of 320 million Americans coast to coast, is a majority of the 9 lawyers on the Supreme Court. The opinion in these cases is the furthest extension in fact, and the furthest extension that one can imagine, of the court's claimed power to create liberties that the Constitution and its amendments neglect to mention." Okay, and he goes on in slides 36 and 37, and you can read them. Basically, his argument is, listen, one of the most fundamental rights that was won in the revolution in 1776 is, besides no taxation without representation, is no social transformation without representation. In other words, he's saying, okay, if you want to make homosexual marriage the law of the land, fine, but do it the constitutionally prescribed way, representation through legislation or through an amendment that gets a majority of the Americans behind it. Now you know you've got consensus and legitimacy. Don't sidestep it with the courts, okay? Again, really good arguments. Regardless of which side you fall on this, these are really good. Again, I'm trying to show you some of the constitutional arguments and the concerns constitutionally by creating new laws, not just for homosexuals, but for all kinds of groups clamoring for new equality. The way the founders set it up, they were fine with equality, but they never wanted the courts they never wanted it to be done through the avenue of the courts. They wanted it to be done through legitimate legislation. So anyway, I'm going to stop there.